Ladies and gentlemen, dear colleagues and friends of the Käte Hamburger Center, Law is Culture. It is a great pleasure for me to welcome you at our forum's evening. Today, Dr. Shirin Naef will speak about bioethics and religious law, the principle of doing good deed and its application in contemporary reproductive practices. The last decades have seen dramatic scientific advances in medicine and biotechnology. The potential is tremendous. Not only may chronic diseases be cured by transplanting organs, but procreation increasingly takes place through medically assisted reproduction. Embryos are being donated and children born by surrogate mothers. This development has resulted in the human body and its parts being targeted for commodification. In a globalized world with markets for every and anything, this raises fundamental questions. What are and should be the limits in the use of the human body and its substances and parts? May the body or its parts be sold and traded in like any other commodity, with gametes or embryos being purchased? Should surrogacy be allowed at all? And if so, may surrogate mothers be paid for their services? Concerning the permissibility of surrogacy, there are fierce controversies in bioethics as well as in different legal systems. Whereas in a number of countries, surrogacy is totally banned, as is the case in Germany and the majority of European countries. An increasing number of countries now provide for surrogacy. However, there is also a deep divide when it comes to the question of remuneration. Some countries allow altruistic surrogacy. In Europe, for example, the United Kingdom or Greece. Others permit commercial surrogacy as well. Why are the body or its parts and substances so special and different from other things? The significance and meaning of the body are notions which are deeply impregnated by culture and religion. They are inseparably linked to concepts of personhood and identity, to perceptions when the life begins or ends, as well as to the notions of family and kinship. Consequently, the commodification of the body or its parts is a very fitting example for the theoretical framework Werner Gebhardt presented in his inaugural lecture last week, as it shows to what extent the legal order of the economy is indeed shaped by cultural and religious norms. To this end, tonight Shirin Naef will explore the merit of good deed in the context of modern genetic and reproductive technologies from the perspective of Shia Islamic jurisprudence and ethics. As an anthropologist primarily working in an interdisciplinary field between law, religion, and ethics, she will demonstrate how concepts such as remuneration and reward, as well as the importance of the act of charitable giving itself, are used as legal and moral principles in the tradition of Islamic jurisprudence and ethics. But before she will share her knowledge with us, let me introduce her first. Dr. Shirin Naef is Associate Researcher at the Institute for Social Anthropology and Empirical Cultural Science at the University of Zürich. Initially in Tehran, she studied theater and English, before then continuing on with anthropology, Islamic studies, and linguistics at the University of Bonn. From 2009 to 2012, Shirin's work was funded by the German Research Foundation, the Deutsche Forschungsgemeinschaft, and she was a member of the Graduate Research Center for Bioethics at the International Center for Ethics in the Sciences at the University of Tübingen. During this time, she also completed a fellowship at the School of Social Anthropology at the University of Manchester. Thereafter, she was a visiting researcher at the Broscher Foundation in Geneva. And in 2017, Shirin Naef obtained her doctoral degree at the University of Zürich with a dissertation on a topic that is very closely related to our topic today, kinship, law and religion, an anthropological study of assisted reproductive technologies in Iran. She has published extensively in her areas of research, including Shia Islam and jurisprudence, bioethics and reproductive medicine, as well as kinship. And since October this year, Shirin Naef is fellow at our center, where she is working on a project that is also closely linked to tonight's topic, Economy, Law and Religion, a study of Shia philanthropy in Iran. And I'm very much looking forward to your presentation, Shirin. Thank you.
Thank you very much. So, hello, good evening. It's a great pleasure for me to be here at the Käte Hamburger Collect Law as Culture, a place that connects me to a very deep intellectual academic European tradition. I'm very happy to be here. Thank you for accepting me. So I started. The theme of my presentation is the importance of discussing the principle of good deed and its application in the field of bioethics. So the notion of bioethics and the origin of the discipline of bioethics and its institutionalization in academic is a modern development. So bioethics, there are many discussions about the concept of bioethics in both European and American tradition, but if we take the common concept of bioethics, in its widest meaning is a field of research by an interdisciplinary approach that deals with the ethical issue about responsible using of bioethical and medical innovation and their influences on human environment. So if we take Duvel and Reich, as I said, in both American and European tradition, even the focus is on ethical question, but at the end of my paper, I am also I consider also this ethical question, and in contemporary time, it's also as much as important as legal questions. So for me, bioethics is both ethical and legal question, because anyway, it needs a regulation. We have a lot of practices in the society, and when we're talking about the regulation, so this bioethics takes also a kind of biojurisprudence, or with law, which is also very important, is how is connected to these ethical questions. Although development in medical sciences and technologies, such as in assisted reproduction and organ transplantation, have provided significant medical and health achievement, they have also caused various ethical challenges and conflicts that located within the bioethical discussion. One of these challenges is as we have here it, a monetary relationship between those playing role in these procedures. Let's see. A monetary relationship is actually an English term, and it's related to the many contexts like egg donation, organ donation, assisted reproductive technologies, or if we go in the beginning from the blood donation, also was a concept that has been also argued. But in my paper, because it's related to assisted reproductive technologies, my focus when I'm talking about monetary relationship, I mean the regulation of relationship between recipients and donor in the context of reproductive practices like practice of egg donation, surrogacy, sperm donation, who gives embryo, who gives egg, who is the recipient of bodily reproductive substances, and how we are going to understand the monetary relationship in the case that is in the context or in the countries that the use of reproductive technologies, especially egg donation and surrogacy, is allowed. I have done over the last 10 years a lot of ethnographic research in Iran on this issue, And my ethnography or my approach was based on a combination of ethnographic fieldwork and also engaging with legal and religious scholar, also medical scholar, both from religious and non-religious setting in Iran. So as I call my approach, it was more a conversation with Islamic law and Islamic jurisprudence, which give me also a deep understanding of law and Islamic jurisprudence, especially Shia tradition. This is the picture I have made. This is the 1 hour or the half an hour after the conception in the labor. So it is not anymore egg, is infertilized egg with the sperm, so in the labor. And this is, the question is how we should understand, I don't say using or buying, rather that how we should understand in the context when somebody take this egg from the donor as a recipient, how we should understand the economic relation between recipient and donors, and in terms of legal and ethical concepts. I'll give you first a brief introduction to the main approaches we have it on the normative level, so in bioethic or ethical discussion. In general, we have two main theoretical approaches to this subject. The dominant approach is considered the monetary relation in organ and tissue donation morally wrong, as the instrumental use of human being is inconsistent to human dignity. This approach, which is found in many theoretical and ethical discussion about blood and organ donation, as well as assisted reproduction, consider any monetary relationship and selling and buying human organs morally unacceptable and leading to commercializing human relation and exploiting the poor. It defines just the altruistic, humanitarian, and non-paid donation morally acceptable. For instance, one of the first articles written in the field of medical ethics on this issue was by John Käte in 1997. It discusses blood donation in Europe, in which he believes that unpaid donation of blood without asking money and reward will lead to consolidation of altruism and solidarity in society. Although this approach is presented within secular ethical discussion, so I do believe that it is rooted in the ethical teaching of Christianity, in which altruistic giving, love, and compassion to others are emphasized more than resolving the financial problem of the needed and poor people. The second approach defines the monetary relationship and paying money for receiving organs and human reproductive cells or using surrogacy in the context of the relation found in the free market, principle of freedom of contracts, and rule of mutual wills. Monetary relation is not morally wrong. John Harris, professor of law and bioethics at the University of Manchester, is one of the most important figures of this approach. I was also during time in Manchester, had a possibility to visit one of his seminaries on that issue. So I don't want to go deep in these two approaches, just to give you that how these two main approaches. We have also a third approach, which has been less discussed in bioethics, but it seems also that when I come back to my research, Shia religious legal authorities, I can situate their response to the question of monetary relation in this approach. So I just mentioned briefly what is the general idea of the religious authorities in Iran, and then I come back and say what I am meaning when I'm talking who are these scholars. So we can see also some picture. I have had an interview during the last 10 years with all these three. I mean, more than, but all these three were also had two or three times I had a possibility to have an interview with them. Two of them are already passed away. And the one here, we see that in his room, I also were I had a possibility to go to visit him at his place and to sit in front of him, you see that, all like those other men there, and ask my discussion. And of course it was not easy. The condition was that I had to read, he has a lot of publication on assisted reproductive technology from the Islamic jurisprudence, and because there are two contexts that legally argue in Iran regarding the issue of assisted reproduction. The one context is related to the fiqh, Islamic jurisprudence, written mostly by those scholars, and they are also legal texts written by law experts. So two different traditions. And it was for me very difficult. I mean, the condition was I asked him, I want to have an interview, and he told me, you have to read first my article. So this is actually 10 years ago. It was in the early days that I started my research. And then I started to read. It was very difficult to understand how they write an argument, how legal reasoning. So it takes me many years. Even I've studied Islamic studies as my minor subject, but it was very difficult to understand those legal language. So now I can claim that I am more or less familiar with that kind of text as well. So after 10 years, hopefully. As I say, a large number of Shia religious legal authorities consider payment for the donation of organs, gametes, embryo, and even surrogacy lawful. So the term is halal, is not ethical subject, is more legal term, is lawful, and define the paid money as wage or remuneration. So there is two words. Later I am coming back to that word, ojrat. So this religious legal scholar emphasized that one who gives her organ and receives money should consider the money as a reward to what she has does and not as the cost of selling or renting her organ. So it's a little bit difficult, but probably among you there are some who are familiar with the gift from Marcel Mauss. For me, this response is more or less the same argument and that we can find in Marcel Mauss' book, The Gift. Even as I discussed with Valérie, in French, the gift is the English translation, but the Marcel Mauss concept is don, when I am right. So it was also, I am also thinking, like the gift in English translation is very secular. It refers to the gift per se. But in the text of this religious scholars, the concept of ojrat is refers to not to the gift, rather to the act of giving. Something that probably also when Marcel Mauss write about don was to emphasize more on the giving, act of giving, not just gift, the concept of gift that we know it in English. So here also, according to many of them, what is most of them are agree with the payment, but they consider the payment as something that is given to the surrogate mother or to somebody who gives egg in relation to what his or she's doing, not because of a rent of her uterus or selling her eggs. So it is, of course, it's really maybe difficult to understand in the contemporary modern context such an argument, but it is also very important. This kind of argument actually makes it possible that the practice of surrogacy and egg donation get its legal permissibility in Iran. So it is. I would like just to quote one of the interview I have, or maybe one of the religious authorities about the surrogacy, to give you a little bit more feeling about how he's talking about surrogacy and payment. So, as I said, in many contexts, we take the surrogacy as example. Payment to surrogate mother will be considered as exploring a woman. So we know that many like American infertile couples goes to India for the surrogacy, and many publications that we have. So consider this is a kind of exploration of the woman's body, or just like payment is a morally wrong. But for example, in one of the interview that one of these Ayatollah Merghati, we see him on the right side, regarding the payment in the case of surrogacy, he says, the surrogate who is offering her uterus to carry the baby may be thinking, God has given me the power of childbearing. Perhaps I can help another family to have a child. Why then do we call this surrogacy exploiting or taking advantage of someone else's body? Don't we have daye? Daye is a nanny, so those who gives take care of the child, or in the past those who give a milk to the child in the case that the mother doesn't have the milk. So don't we have daye in Sharia? Here he means Islamic culture rather than Sharia as law. Don't we have madar rizai, milk mother? These were never associated with exploiting in the past. A woman would have said to another, now that you cannot, I will breastfeed your child. So he compared the surrogacy with the case of breastfeeding, and argue as in the past there was no exploiting, so it was a kind of reciprocal relation between two women, and he argued with those arguments in the context of surrogacy. So if I just, this kind of, later I come back to the concept, but it is to say at the normative level, altruistic giving, according to this religious legal scholar, altruistic giving and financial compensation can constitute a good without contracting to each other. So this is... so that the money, paying money and doing a good things could be morally acceptable in the context of bioethics. So now I would like to go to my ethnography on surrogacy and take my own conclusion, but before that I need to a little bit explore the context. So in Iran has actually has a very permissive approach to the use of reproductive technologies. It is very difficult. I don't want to go to the history of the birth of embryo donation law, but just to mention the Iranian parliament in 2003 has approved a draft law called Law of Embryo Donation to Infertile Couples. So if we look at to the from the beginning, I also was involved in studying the argument and regarding this law. It's if we look at to the birth, if we say what is how it's happened, with the medical improvement and the possibility of we have in the context of biotechnology. There was a lot of discussion among medical, legal, and religious scholars on that issue, and there many medical scholars prepare some question regarding the permissibility of use of these techniques. So then they ask this, goes with this question to the legal authorities, religious authorities. In this conversation, like it is allowed to use the embryo donation, or what is their juridical idea, legal idea on the use of, on the permissibility of embryo transfer. With this kind of questions, many of religious authorities try to write and develop their legal and juridical idea. And so in interdisciplinary cooperation or discussion with civil legal lawyers or experts in Iran, religious authorities, and medical, with a lot of conferences, national conferences, local conferences, the idea of possibility of embryo donation becomes an idea accepted by many religious authorities. In fact, this permissibility has a religious foundation. And as you know, probably Iran, the Iranian civil law is based on Islamic jurisprudence, especially in the issue of family and kinship. And with this permissibility that comes from the religious authorities, fatwa, Iranian legal experts proposed a law to the Iranian parliament, and then goes through again to the religious authorities, guardian council, and gets approval. And since 2003, this law, it works, and as we can see that I come maybe later to that one. So as we can see, according to the Article 1 of this law, the transfer of an embryo resulted from the IVF, an embryo resulted in the labor, is possible to the another married infertile couple. So a married couple could donate their embryo resulted in the lab to the unmarried couple who want to have a child. And also, I mean, as we say, it is one of the main principles here is the marriage. So embryo, and this comes also again from the idea of moral and legal understanding of embryo according to religious authorities. And as we embryo takes a legal meaning because it's resulted from a married couple, and also because it is formed in the lab, there is no sexual activity to formation of this embryo. So this is very important because it seems it's very liberal, but if we look to how legal reasoning is happen, it's actually very traditional understanding of bodily substance. So embryo doesn't take a legal meaning because it's resulted from marriage. And because of that, many religious authorities give the permissibility to the transfer from one married couple to another. In the case like adoption is not allowed in Islamic law, but it is allowed to adopt the child, but the child is not your own biological child. So let's say biological legal child, but the adoption is possible. Again, also in the case of embryo donation, it is allowed for a unmarried couple to receive this embryo, but the real parents will be, according to religious authorities, are the father and mother, the donor of the embryo, those who give the embryo. But because of the woman, in the case of transfer of embryo, those who are infertile give a birth to the embryo will be considered, according to civil law, the mother of the child. So it is a little bit complicated. It is not also the subject of my talk today, but I wanted to just give you the idea how these religious authorities have a lot of principle to argue if it is allowed or not. And this principle is really related to the construction of kinship. Kinship is a very important concept in the Islamic jurisprudence, nasab, And based on understanding of this nasab or filiation, the French word I prefer to use in this context, Shia religious authorities have different idea how this filiation is constructed, and this is exactly where that they are differentiated with the Sunni legal authorities. Sunni legal authorities give more meaning to the male filiation, and Shia religious authorities to both female and male. At the end, the makes also many differences that we, according to Sunni religious authorities, the use of embryo donation, for example, is not allowed, but we see that the Shia religious authorities take another definition. But as I said, when I will come back here again, this is also those of legal, as we see that medical and religious scholars who are involved in debating bioethical issue. As I said, this was like a very interdisciplinary approach to this question. Another thing that was also again the question of legislation. It is also important to understand what is the difference between the concept of Islamic jurisprudence, fiqh, and huquq. If we want to understand this legislation, Islamic jurisprudence, fiqh, is very related to practice. I'm not talking here about the Sharia. Fiqh is the legal discourse. And in Shia tradition, is the religious authorities, we don't have a kind of consensus. Each religious authority has his own juridical understanding of the case. So it is also a little bit different to the Sunni tradition. And at the same time, we have the concept of huquq. Law is actually it's a very modern concept. Huquq in the Islamic Persian language is a plural form of haq. Haq is right. Is a very old concept, but the concept of huquq comes from the translation of the law from French to the Iranian. So to understand all this regulation in Iranian context, we have to be aware also there is these two traditions based on the French civil law and also Islamic jurisprudence, because in the structure and subject, the Iranian civil law has taken its form from French law. But based on the Shia jurisprudence when it's come to the value and the families issue. So it was just some important things to understand the nature of this law. Here we have also. Okay. And as I say, there are also some concepts, I talk in the context of embryo donation, that it is the embryo has the concept of legitimacy and purity. Legitimacy, as I say, refers to the context, that's to the marriage, as I say, and the marriage embryo resulted from a married couple, and the purity is also the absence of any sexual act. The embryo will be has its formation in the lab. There is no any illegal sexual act out of the marriage context. So, but I would like to come back to my actual main subject of my talk today. So, monetary relationship. As we see here, there are some concepts like sawab, religious reward, amr khair, good deed, ujrat und aj. So, wage or remuneration. This is the best English translation I could find for this word. But as I said, they are the concept that has its root in the religious understanding of people and religious authorities. So I would like to come now to my ethnographic research. I have more than 10 years ethnography on surrogacy in Iran. During the first, this is two stages. During the first part of my ethnography, I have observed a lot of practices of surrogacy, and I say surrogacy is also allied best of the law of embryo donation, because the law of embryo donation regulated the practice of embryo donation a woman can carry an embryo from the other married woman is also, this is also a surrogacy. I mean, from the legal point, it doesn't, between surrogacy and embryo donation, there is no difference actually. But in the surrogacy also, a woman carry an embryo of married woman who actually cannot, the woman cannot give birth, but another woman carry her child. So in this context, but how they are define the monetary relationship, referring to this concept even has their also in normative texts used by many religious authorities, who consider, many of them even consider the payment as a good deed. Why not? If a woman doing something, it is good to pay her for what is he's doing. But during my first part of ethnography, I had observed also, I had the cases of surrogacy. Actually, payment was also the case, but I see that there is a good, it works. So it's the surrogacy, in many cases I have, was in good cases that both couple were happy at the end. There one couple, they wanted to have a child, and there were also another couple or woman who needed that money. I mean, it was, I have to say that, I mean, in Iran, many of cases I had were also from the same social middle class background. I mean, they were not definitely poor people. There were also many, like also poor and from middle class women who wanted to use the surrogacy, and they had a problem with infertility. In the first, as I said, 8 or 10 years, there was like the practice. In the practice, those people who wanted to do that, they come to the clinic, ask, I want to be a surrogate. Most of them will be introduced by like charity organization or even religious authorities. So the people involved in this kind of transaction, they don't ask themselves money, like those who introduce, like religious authorities. Some surrogate mother goes, some people goes to them and say, I have a problem of if you can find something for me, or there is something in my life, if there is a solution that I gain, for example, money from somewhere, and they suggested them, okay, if you are happy, if you can do that, I know an unmarried couple, they needed surrogacy, so we can introduce you. I had the cases like local religious authorities who bring people together, and those people who bring the surrogate mother and intended mother together did this based on a good act, a good deed. And as I said, it for me, it was the reason that surrogacy is function. But if I'm coming back to the second stage of my research, that Iran went a kind of neoliberal value becomes more important, so the change, I mean, this kind of practices, and also very over-commercialization in the clinic, so they were already used, and then involvement of another group of people who act as I don't know how we call them, as those who work in this field, so who bring the people together, but they ask also money for this, for that action. So it were people who either work in the clinic, or they were also unofficially around the clinic. They become like a third people in this monetary relation, and they introduce people together, but they ask money from both parties. So these kind of things give another form of quasi-practice of surrogacy in Iran. And it becomes, I mean, it was not anymore like, I didn't hear anymore such a concept. So it was like more contract, more, okay, we are introduced you together, so I am also doing something, it costed like that, you have to pay this, you have to pay that. And it becomes like, it brings me to think about what is actually happening here is more that kind of value, that kind of concept that it has actually its roots in this religious moral tradition of society, lost in the context that gain more, move more in the quasi, or take more in this new liberal value. And this was for me also at the time that I started to think about how law and economy can be analyzed in the field of bioethics and medical humanities. So this is like, it gives me to think about that through Durkheimian tradition, to think about the importance of the religious concept on the moral understanding of the society. So these experiences during 10 years leads me actually to this question, how we should reflect and understand these two relations between economy and law in the context of bioethics. And I am arguing that we should rereading of Durkheim's school of sociology, Durkheimian concept of solidarity, what I have been observed in the first part of my ethnography. In the second part, it was not the case anymore. Or rereading Mauss anthropology, like the concept of gift, the concept of giving. Also, I'm arguing for the rereading religious and moral concepts, like in all the religious tradition. I mean, I did it myself in the Shia Islamic tradition, but also it is also important to be familiar with the Christian or Jewish tradition or other not Abrahamistic religion. So now I am trying to develop my own idea based off this ethnography, and also based off this argue that I have here. I think it is possible, but we need to reflect on more on the moral and religious concept that we have in all these traditions. So I didn't read any more from my paper, try to speak like that. I hope it was more understandable. So if you let me, and I am very happy also to be here, as you see that with the picture of Mauss in my office. So I am also working now on his concept again. And I would like to read also a quote from a German philosopher, Volker Gerhard. He's the professor of philosophy at Berlin University, has written a very nice book on zur aktuellen Debatte über die Biopolitik. And sorry for my German pronunciation, I try to read it. Bei der Regulierung der Biopolitik können wir nur auf die Kraft des Rechts und auf die Wirksamkeit der Institutionen vertrauen. Die Politik, die in ihrer Geschichte stärker als Kunst und Wissenschaft die größten Maßlosigkeiten ermöglicht hat, weist auch die größte Erfolgsbilanz in deren Überwindung auf. Damit diese in Zukunft nicht in der Nivellierung endet, haben wir die Kontinuität gerade mit den großen Leistungen und den erhabenen Prinzipien der menschlichen Kultur zu suchen. Dazu gehört der Aufweis der moralischen und politischen Quellen unseres Selbstverständnisses. Sokrates ist uns näher als die verhängnisvolle Selbstauszeichnung der Moderne es bis heute glauben Menschen will. Sollen der Athen durch die Entschuldung der Armen, durch die Wiederherstellung des Rechts und durch sein vorbildliches Leben auf die Demokratie vorbereitet hat, darf immer noch als ein exemplarischer Politiker gelten. Und Konfuzius, Salomon, der Prediger Kohelet, Buddha oder Jesus sagen uns heute immer noch mehr über die Grenzen des menschlichen Daseins als die Expedition ins Weltall oder die Kartierung des menschlichen Genoms. So hat natürlich auch, kann man dazu die islamische und die jüdische Tradition fügen.